Economic Freedom Fighters wants Parliament to repeal the Riotous Assemblies Act, which the Constitutional Court has declared invalid. The party has been challenging the constitutionality of an aspect of the Riotous Assemblies Act. The EFF is planning to introduce a parliamentary process. I'm now joined by Nthabiseng Dubazana of Dubazana Attorneys to take us through exactly what this means. Nthabiseng, thanks a lot for joining us this evening. I mean, how momentous is this, particularly for the EFF?
Well, this is a monumental win, and I don't think only for just the EFF, but as the country as a whole, considering our country usually expresses frustrations and whatever you have it through riots and protests and etc. So the Constitutional Court declaring part of the Riotous Act unconstitutional is pretty big, because it now says that it's giving people the right, it's enforcing rather the right of freedom of expression of people. As Mogoeng said, I was actually reading the judgment before calling, or you guys called, whereby he insists that in our democratic society, these apartheid-based acts were favorable for Europeans than they were for the people who are original inhabitants of the land. So he was trying to make sure that when he's limiting the rights, or rather when we are now putting the aspects of the Riotous Act into question, if they fall within the ambit of our Ubuntu society and constitutionality, that it doesn't also trample on the rights of other inhabitants of the country. So this is a very big win.
Yeah, I mean, speaking about a big win, one would say that I'm sure EFF leader Julius Malema feels quite vindicated. I mean, he was charged twice as a result of this Riotous Assemblies Act in itself. And it certainly is egg in the face on behalf of government, is it not?
Yes, it is. And the nice thing is that now they've now been given, 24 months to rectify the act. And in the meantime, it is given how it should read while we are waiting for Parliament to rectify the situation, whereby it used to say that you will be charged, rather you'll be convicted as if you had committed the crime. So now it's going to read that during the period of suspension of the order of invalidity, any person who incites, instigates, commands, or procures any other person to commit any serious offense, whether a common law or against a statute or statutory regulation, shall be guilty of an offense and liable on conviction to the punishment to which a person convicted of actually committing that offense will be liable. So sometimes you wouldn't even be have been convicted, but then you'll be treated as if you're going to be convicted, and then therefore you're going to have a previous conviction. It was basically a way of making sure that people who are trying to express themselves, their anger, their frustrations, will be curtailed and stopped from doing so. Otherwise, you're going to get a previous conviction.
Let's talk a little bit, Nthabiseng, about the existence of such apartheid-era laws still in our constitution, still that is being used by a judicial system. I mean, when we're looking at this particular one, one would say that we still have to contend with the fact that we are using apartheid-era laws in a democratic dispensation. That means that as a country, though we've come far, but certainly somehow we're still working backwards in terms of even our judicial system.
100%. And it's not as from a lack of trying. Some other laws right now are not being put forth to the Constitutional Court for them to be reviewed. But there is what is this? The approach to the court whereby all apartheid era laws are now being looked at to now not fall within our democratic era. But unfortunately, most people who suffer from other laws that are not in the public eye, like this one, suffer the consequences of those laws which are still in existence because they have not yet been challenged. So it is, remember, challenging any kind of act or law consists of a lot of money. So most people who are being abused by the system or by the legal system in these under the apartheid laws don't have the monetary funds to take this matter up to the Constitutional Court. Yes, sometimes it's pro bono cases and human rights, the human rights places try and assist people in these manners, but it doesn't cover everything. There's a lot of work to still be done in the legal fraternity, to be quite honest.
Yeah, but then one wonders if there's even political will to do this work. I mean, it just sounds like it's either A, we do not have the adequate manpower as well as the adequate specialists, which I doubt we do if we don't, to actually contend with some of these laws and rewrite some of those injustices, or there's just a lack of political will to actually undo some of the laws that were there to perpetuate a stigma and segregation of a black majority.
Well, it could be that the latter, if you look at it that way, that the political view of trying to challenge this might destabilize the country. It might show a cause for riots and fights or civil war, whatever the case. These are the things that we hear when we talk about such laws being challenged, that let us not disturb the peace that is currently here. Let sleeping dogs lie. But it's not helping us move forward. That's the first thing. The second thing, those of us who are in the legal fraternity, not all of us are in the process or in the ambit of rewriting the laws. That also in itself, to be able to rewrite the laws, and then it has to go to the NCOP for it to be approved. Remember, we have separation of powers. So now it's going to be a whole debate as whether or not it will be acceptable or not. It has to be debated in the parliament, and then it has to be sent to the public, and then all of that. So it's going to be a long way to transformation, but it is possible. I think we will get there. As to how long it will take us, I'm not quite sure.
One would say, Nthabiseng, it is a long walk to freedom. Very quickly, before we let you go, does that mean that Julius Malema now walks free for now?
For now, yes, for now, especially regarding to the Riotous Act, it's been dealt with as unconstitutional, which means the conviction or thereof back then doesn't apply currently.
Nthabiseng Dubazana from Dubazana Attorneys, they're giving us insight into that monumental ruling by the Constitutional Court regarding the Riotous Assemblies Act being found to be invalid in a constitutional democracy.